Okay, I think we can go ahead and get started. I wanted to thank all of you who are on the call and webinar today. I'm extremely excited about this webinar, but I'm even more excited because we do have Ms. Shannon Jenkins on the line, who is a partner with the law firm of Treadway, Lumsdaine, and Doyle here in Southern California. And Shannon has a wealth of experience in employment law. And myself and Shannon are constantly working together through compliance issues, both on the background screening side of the proactive service, and then at times when employers have, any kind of liability or litigation, then Shannon is able to assist them with anything that they need. She's very versed in employment law. We use their firm for special engagements, and I just wanted her to be on the call so that she could put the legal twist on what it is that I'm going to be sharing with you with regards to myths versus facts related to compliant employment background checks. Right now, currently, the background screening industry is very fluid. It's constantly changing. With the new year coming up here shortly, and of course after the election, there's going to be a boatload of laws and compliance issues that employers are going to be faced with, and they really need to take a proactive approach in combating that. They're taking a proactive approach by doing background checks, but more importantly, you want to make sure your background checks are in compliant so that, again, you're lowering any kind of risk and liability. So for those of you that don't know me, I guess I put the wagon before the horse. My name is Cody Farzad, and I'm the Vice President of Employer's Choice Screening, and we are a nationwide employment background screening, drug testing, and physical provider. So we help employers in different industries, different employee size, hire the right individuals for the job and make sure that they are making a well-informed hiring decision. So, and again, with any kind of questions and answers, if you guys don't mind utilizing the chat feature in the upper right-hand corner of the monitor, you go ahead and ask your questions. And we really want to make this more for the attendees. So the content, I don't anticipate going more than maybe 35, 40 minutes. So we'll definitely have enough time for Q&A, and I want to get you guys out of here, by 11 or maybe a little bit before 11. But we have a lot of information here that we need to get over, so we'll go ahead and jump right into it. So this is our disclaimer. Obviously, we're not attorneys, but Shannon is, and we don't, per se that this is legal advice. We do provide, information to our employers and clients, but in no way should this be construed as legal advice. If you do need help with that, I could definitely get you in contact with Shannon and the people over at TLD. Real quick about Employer's Choice. We're a provider of on-demand employment background checks and drug testing services. We've been doing background since 2002, and since we are in California, we do have a wealth of information and education with regards to background checks, because California is one of the most tightly regulated states when it comes to employment background checks. We do backgrounds, in all 50 states and also international screenings. We tailor the screenings around the specific job duties and responsibilities that the employee is going to have with the organization. So why is compliance so important when we are doing these employment background checks? Currently, there are a wealth of class action lawsuits being levied against background screening companies and employers for violations of the FCRA. And the FCRA is the Fair Credit Reporting Act, which regulates what can and cannot be reported on an employment background check. It also speaks to the disclosure and authorization form that employers must get from the subject of the report authorizing the background. It also goes over notices and disclosures that the applicant must receive, stating their rights under the Fair Credit Reporting Act and state law. If the state they are in has their own specific employment background screening laws, they have to receive that notice as well. And it also speaks to the pre-adverse adverse action process when deciding not to hire an applicant based on the background check. In some cases, civil penalties run between 1 to 10,000 per class member, and these classes could be very, very large. The Equal Employment Opportunity Commission is the main culprit. They're the ones that are very, very active in bringing lawsuits against employers for the way that they are doing their background checks. This ties right into kind of Ban the Box, which is a whole other webinar in itself, but Ban the Box, real quick, is a trend that's sweeping across the U.S. where it regulates when employers can ask about previous criminal activity, and also speaks to how they handle the pre-adverse adverse action process. Real quick, in 2011, there were about 2,000 FCRA class action suits. In 2015, it increased to 2,700, and I'm fully confident that this year that number has risen as well. Shannon, do you want to speak to any of this here before we move on?
No, I think all of those are legitimate points, so I agree with you on that. Compliance is critically important, and over the next few slides, let's talk about what that looks like.
Absolutely. Okay, so let's move on. So compliant background checks. How can employers stay compliant? What do they need to look out for? Who is pushing for further compliance? Like we talked about the Fair Credit Reporting Act, that is enforced by the Federal Trade Commission and also the Consumer Financial Protection Bureau. So those are the two federal agencies that enforce the FCRA and essentially is the governing body when going after employers and background screening companies. We talked about the EEOC and their guidance on what employers should look at when getting a background check that has adverse information. So they want you to do away with kind of blanket statements. They really want to take an individualized assessment approach, having a conversation with the applicant, and just going over the details of the specific adverse information that the employer wants to take action on. We talk about Ban the Box. Basically, that's doing away with the question on the application inquiring about previous criminal activity. Some states and cities want you to ask it after the initial interview. Some cities and states say that you could ask it during the interview. And also, there is regulation and laws out there stating that you could only ask once an offer of employment has been extended. California law, California does have their own background screening laws with regards to reporting periods, with regards to the disclosure and authorization form. And again, there's a lot more hoops and hurdles when doing background checks in California as both the background screening company and the employer. There is a credit restriction for credit reports in California. They really want companies that are doing credit reports to make sure they're requesting them because of the duties and responsibilities of the applicant, being in a financial position, having fiduciary responsibilities, things like that. And also out-of-state compliance. California is not the only state that has their own laws pertaining to background checks, but other states as well, like New York, like Illinois. And it's really important to utilize a company that has the wherewithal to know different laws and regulations in specific states, especially for those clients that do operate in multiple states as well. Also, professional associations help with compliance. We are a founding member of the National Association of Professional Background Screeners, and that association really helps us with education, best practices, and industry standards that we like to pass on to our clients. So we'll go ahead and talk about myth one, online nationwide database searches. So a lot of employers, when doing background checks, kind of, they really don't know what's out there. They don't know what information they could pull. They don't know what information they could use in making a hiring decision. A lot of them feel that they could do essentially a nationwide database search, and it's going to be in full compliance, and it's only going to give them information on their applicant, and they want it for a very, very economical rate. Online nationwide database searches, they will reveal criminal records on an individual. These proprietary databases have, upwards of 500 to 600 million records being contributed from different sources nationwide. Counties do report criminal records to a nationwide criminal database. State repositories can report criminal records on a nationwide criminal database, and other police agencies and things like that. So it does have a wealth of criminal record information on consumers in it. A lot of clients think that the nationwide criminal database has the most up-to-minute updates and information in it. And that's just frankly not true. And we'll address the actual facts of the nationwide criminal database later on in the presentation. A lot of employers feel that it matches a Social Security number based on the subject of the report. So they feel that a Social Security number factors into reporting criminal records from a nationwide criminal database. Also, it's a misconception that case information is all up to date and there's no need to do further research, that you're going to get all the details of the information, the arrest date, the conviction date, the disposition date, and all sentencing information. And we'll address that later on. Another misconception is it updates all 50 state sex offender registry sites. So as each state's registry is being updated in real time, a lot of employers feel that they're going to get that information from an online criminal database search as well. Myth number 2, anything and everything is reportable. A lot of employers feel that they can get information from the applicant from when they were 18 years of age and be able to report on anything. You could use all past criminal records on an individual no matter how much time has passed since the conviction. They also feel that they can make employment decisions based on information they're receiving from their background screening vendor for arrest records. So if an individual was arrested, employers are sometimes getting information from background screening companies that are just showing arrest records. And pending cases. So an individual has a pending case for whatever the charge is. Sometimes employers are receiving that information and making an employment decision on. Dismissed cases. The individual is, let's say, arrested. He goes or she goes to court, and it is later found that the case is dismissed and shouldn't be reportable at all. Expunged records. Individuals can be convicted of crimes, and if they do complete their post-sentencing requirements, they pass probation, they can petition the court to get their records expunged. And also receiving criminal information where the individual was found not guilty. So, employers unfortunately are receiving information like this from their data providers, and unfortunately, they are using it in making an employment decision. And we'll again talk about the facts of what is reportable and what employers, can and can't use. Anything here, Shannon, that you want to talk about with regards to expunged records or dismissed cases, anything like that? Have you seen with your clients them getting in kind of hot water for using records that should have been reportable?
No, you know what, we have not, but what we've tried to do is stay ahead of the curve. If we're going to have employers who are still going to continue to ask for criminal conviction or criminal history data on their employment applications, we make sure that they are crafting the question or the interrogatory such that they're not going to, people know straight up, right on the face of the application, they're not going to be required to provide information about expunged records or stuff that you cannot ask about. So hopefully the reason why I haven't had a bunch of issues with people getting in trouble for using prohibited data is because we're ahead of the curve on making sure we don't request that data in the first place.
Right, and that, exactly, and again, that's why, we provide a proactive service and again, kind of stay ahead of the curve and let them know that if you are or going to be doing background checks and receiving this type of information, it's really important to reevaluate, your background screening vendor.
Absolutely. And the other thing I wanted to jump in here and add is I just received an update from the Labor and Employment Law section of the State Bar of California, and there was a bullet point regarding background screenings, and it reads as follows, and maybe you can add some more information to this, Cody, but here we go. It says California, now with the close of the legislative session, California employers will generally be forbidden from asking applicants about or relying upon information related to the arrest or conviction of the applicant as a juvenile. And that's Assembly Bill 1843. And then it says California law already prohibits consideration of arrests not leading to conviction, pretrial diversions, or convictions that have been dismissed or sealed.
Right, right, and that was kind of the philosophy with juvenile records, is that they are the ones that essentially could get a second chance, because juvenile records should be sealed, and juvenile records should not be reportable because it violates, you know, the FCRA and state laws. And again, you know, if they are entering a pretrial diversion program, that conviction is set aside. If they complete the pretrial diversion program, it is essentially becomes non-reportable. But you know, there are you know, background screening companies out there, again, that are reporting that information, and employers, you know, they're just looking at what the case, you know, conviction is, or what the charge is, and essentially the individual wasn't convicted, and it, you know, anyone could be arrested for a crime, but if it is determined that that they were found not guilty, or that the you know, the state or county doesn't want to pursue any charges, then that shouldn't come up on a background check, and really, you know, it becomes a barrier to employment when this kind of information is being shared with employers, because the individual, and sometimes the consumer, they don't know their rights. They're not receiving the notice with regards to what is and isn't reportable, and you know, they are just going on and hopefully processing with another employer that will get compliant background check, and that information not coming up on their background.
Yeah, and the other situation that has come up regarding questionable items that people are wanting to, you know, I guess the point is, just because you can have access to it doesn't mean that you can use the access or rely on it in any way. And where this comes up for me particularly, in fact this just happened a couple of days ago, is an employer wanted to pull and rely on workers' comp litigation history and workers' comp filed cases, as well as Megan's Law database information.
Right.
So maybe you can speak to the reportability of those two items.
Yeah, so with workers' comp, as part of the background screening process, there are compliance issues. The two major ones is, and this is before Ban the Box, is that an employer has to make a conditional job offer to the applicant before they're going to pull any kind of workers' comp claims filed. The second compliance piece is that they cannot make an employment decision strictly on a workers' comp claim. The information that you get from the state with regards to a claim is very, very limited. You may get an individual's name and claim date, but that's all you're going to get. You're not going to get the details of the return to work or limitations or any kind of doctor's information, because that would then become more of an investigation. And frankly, it could be a legitimate, you know, workers' comp claim, and you cannot discriminate against someone that has a workers' comp claim. More importantly, for those nationwide companies, this type of search isn't available, you know, in every state. So, you know, if they're relying on a workers' comp across the board, they potentially can't pull that in a state that they're operating in. With regards to Megan's Law, the sex offender registry, you know, it has its opportunities there as well. And any, you know, sex offender information that we get, we research and need to find the original case to see, you know, where jurisdiction it was in, because again, with these databases, especially with the sex offender databases, they're a name match only. They're not matching, you know, the name and date of birth with a traditional county criminal search. They're just doing a straight name search. And really, if you get a hit on that, the background screening company has to do due diligence and validate and verify that the subject of the report is the subject that's on that Megan's Law or sex offender site.
Great, great answer. Thank you, Cody.
Sure. Moving on, I don't need to notify the applicant about the background check. So a lot of employers, and no fault of their own, they're kind of taken back when they hear that they need to get a signed disclosure form from the individual. They don't want to, I don't know, they don't want to scare the individual, or they don't want to have to ask for that information. They feel that they could do just their own background check, and that's frankly not the case. So kind of the misconception is the applicant consent isn't required. The applicant doesn't have any rights when it comes to background screening. I don't have to notify them if I decide not to hire them based on the background check, and I already have a standard release. This comes up a lot of employers have their own standard release form in an employment application. So they have it in an employment application, and at the end, in very, very small letters, it says, you know, as part of our hiring process, we do employment background checks. Please sign this authorizing a background check to be done. And frankly, that violates the FCRA because the disclosure and authorization form needs to be a completely separate document away from any internal employment application or any internal forms, because the disclosure form has certain information on it that an employer essentially can't ask, but the background screening company needs in order to do the background check. More importantly, it needs to disclose the contact information of the background screening company that's procuring the background check in the event the applicant needs to dispute the information as part of the pre-adverse adverse action process. And we'll get into that when we start talking about the actual facts of these different issues. So the disclosure form, it's a very valuable document. It's a very compliant document. It needs to have certain information. And I've seen, even from other background screening companies, very poorly written disclosure forms that, frankly, you know, wouldn't hold up in the courtroom. So if employers do have a section in their application where they reserve the right to do the background check, and they do have a third-party background screening vendor, the third-party background screening vendor, it's their responsibility to provide their disclosure form, their notices, because they're essentially the one owning the process. We'll go ahead and move on to myth number 4. This has to do with kind of fingerprinting. So there's certain industries that regulate certain companies with regards to churches, with regards to in-home health care, education facilities, Department of Justice, financial institutions. So these types of industries kind of fall outside of the scope of you know, the FCRA, and they do fingerprint searches. And it's a misconception that live scan fingerprinting is the coup de grace, the one all be all, the most comprehensive search you can do. And frankly, there are more limitations in these live scan fingerprint searches that they do. They access the Department of Justice and FBI databases thinking that it covers all jurisdictions. So again, going back to that kind of nationwide criminal database search, a lot of employers feel that when they do a live scan fingerprint search, they're going to get information nationwide on the individual. They also feel that there are no accuracy issues. So again, do all of the case details reside? Was the person convicted? Has it been you know, disposed? And frankly, there are a lot of limitations with these databases. Quick turnaround time. A lot of employers feel that a fingerprint live scan, because of the automation now, that they're going to get the information in real time, and frankly, the turnaround times are extremely delayed. They also feel there's no limitations on the reporting period, and you know, there's a lot of inaccurate information on the live scan fingerprint that that companies are utilizing. Again, it's kind of a big gray area right now in our industry. We're trying to push for, you know, a more traditional background check where we're doing the trace, we're identifying jurisdictions where the individual has lived, and we're doing a county by county search. We feel it's as reliable and as accurate, or even more, than a live scan or fingerprint search, because it's frankly, you know, there are inaccurate information, and it's extremely hard to dispute that information and get that information redacted or deleted from that individual's background. So live scan, although it is required, employers need to understand that there are limitations in doing these searches as well. And we have actually helped clients in more of vetting the live scan by doing our own background and kind of matching what is it that they got on the live scan and what is it that we're actually reporting, and seeing if it is compliant based on, you know, on our standards. Now we're actually going to get into the facts and kind of dispel the myths that we talked about. So going back to a nationwide criminal database search. So if employers are doing a nationwide criminal database search on its own. They're not doing any kind of county level searches. They're not doing any kind of trace to identify jurisdictions where the individual is in, is extremely reckless and frankly can increase their liability in doing background checks. So the Fair Credit Reporting Act has identified two limitations with nationwide criminal database information. First off, the information is not updated in real time. Some of these databases are updated on a quarterly basis. Some of these databases are updated on an annual basis. And some of them, are updated on a monthly basis. Meaning, if an individual was convicted of, let's say, a sex-related offense last week or 2 weeks ago in a county that does report records to a nationwide criminal database, that's not going to show up. And that record is going to be completely missed because these databases aren't updated in real time. And there's really no set time on when the information can be available. A lot of county courthouses don't even report information to a nationwide criminal database search. I would say on average there are probably 20 to 25% of counties that just don't report records to a nationwide search. You actually have to go into the county and do a real-time hand search to see if there's any criminal convictions. So again, the two limitations, and their big limitations, is that the information is not updated in real time and it doesn't cover every single county or jurisdiction in the U.S. The second one is majority of records on a nationwide criminal database search is a name match only. So can you imagine doing a search on a John Johnson or a Juan Gonzalez and getting a boatload of information from a criminal database search? Having to sift through that, having to find additional identifiers is very cumbersome, but it's something that needs to be done. So what we do is we do a nationwide criminal database search in addition to county level searches to see if there's anything else outside of where the individual has resided. If we do get a hit on a nationwide criminal database search, we've identified that it does belong to the subject of the report, then we have to go into the county that actually has that record and pull that file and report both the nationwide criminal search and back it up with the actual county level search. The third point here is accuracy issues. A lot of these nationwide criminal database searches will have what we talked about, just arrest records, expunged cases, dismissed cases, not guilty cases, arrest records. And again, those are not reportable. But a lot of background screening companies aren't vetting the information and is just sending that nationwide criminal database to the employer and just letting the employer have to deal with, well, what is and what's not reportable. And frankly, the employer is essentially paying a third party to do that for them. So there are major limitations in the nationwide criminal database search. The fourth point, it should be accompanied by a county level criminal search. You need to get all the facts of the case before you could report it. So it really needs to be researched in the county of record. The last point here, any case reported by these databases must be researched in the county. I cannot drive that point home enough. Accuracy is extremely important. We like to stress accuracy, turnaround time, and a competitive rate when selecting, a background screening vendor. It's extremely important. Not everything is reportable. So pursuant to state and federal law, only convictions are reportable within the last 7 years, where they're either found guilty or they pled no contest. And the clock starts from the disposition date, so when they were convicted. They didn't serve any jail or prison time, it would start from when the judge said, all right, you pled no contest or you were found guilty on this date going forward 7 years. So today, we could report information if they didn't serve jail or prison time from October 27th of 2009. Anything before that should not be reportable on a background check. And again, going over the dispositions that aren't reportable, pending records, if they do have a pending case, that's essentially not reportable because what if they're found not guilty? It's not a conviction. Arrest records, expunged records, not guilty, and dismissed cases. I can't drive this point home enough because again, employers are getting that information and in some cases, background screening companies are releasing all liability to the employer in their service agreement. So if they are being put, in litigation, they are going to court, they're going to say, you know what, the end user of the report, the employer completely released us of any kind of liability, and then the employer is just left there in the dark and then has to bring Shannon in to kind of clean up the mess that was caused. So for those employers there that are engaging a third-party vendor, it's really important to read your service agreement and make sure there are no types of release of liability in there, so that when litigation is being brought, they are covering you as well. Mutual indemnification, if the background screening company is reckless in the information they're providing, they should cover the employer. If the employer completely know their rights and they're reckless in utilizing the information, then they would cover the background screening company. So it really needs to be reciprocated. I need to notify the applicant about a background check. Absolutely. So the applicant consent must be given before a background check is ordered. So you identified an applicant, you get the application, everything's good, you interview them. In the interview, you decide, you know what, as part of our hiring process, we do background checks. Please complete this disclosure and authorization form from our background screening vendor. They complete it and give it back to the employer. The employer must also give them certain notices. The main one is the FCRA, the federal notice, their rights under the Fair Credit Reporting Act. It's a 3-page notice. It was created by the FTC. It's available online, and that's a form that must be given to any applicant nationwide when a background check is going to be done on them. Furthermore, there are certain states like California we talked about. There are 2 additional notices that California residents must receive. If a credit report is going to be done on them, there are 3 notices. The consent form must...
Cody,
yes.
Can I just jump in here real quick? For the employers on the line, for the employers on the line, can you give your insight or wisdom on, from a timeline standpoint, when in the hiring process number 1, are you going to give the notifications, and number 2, are you going to actually conduct the background check?
Right.
Because I think, and what would best practice be? I mean, I would think best practice would be you provide the notifications before the offer, and you conduct the background check post-offer. But let me know what your thoughts are on that.
Right. So this ties into Ban the Box. So employers really need to understand, in their state, in their city, if there are Ban the Box laws. And frankly, they're all over the board right now. Some laws state that you could ask about previous criminal activity and initiate the background check during the first interview, after the first interview, when a conditional job offer is made. I would say best practice is you get the application, you interview the individual, everything looks good. During the interview, you decide that you want to give them a conditional job offer contingent upon passing the background check. At that time, you could have a conversation with them and ask them, specifically, as part of the hiring process, we do background checks. Is there anything in your background that you feel would disqualify you from employment? And just be completely transparent and have them explain, anything and everything, so that when you do the background check, there are no surprises. So to answer your question, it would be a really good idea to find a good high-level applicant, interview them, give them an opportunity to explain during the interview about any kind of previous criminal activity, and then give them a conditional job offer right then. And as part of the conditional job offer, then you would give them the disclosure form and notices at that point. So really, I think that the industry is moving towards having all employers give a conditional job offer first before they run the background check. Does that answer your question?
Yeah, very good. Thank you, Cody.
Absolutely. So, again, it's, there's about 20, now there's about 24 states that have Ban the Box law, and about 100 cities that have Ban the Box law, and it's all really different right now. Even how you handle the adverse action process is very specific in some cities as well. New York has a very, very stringent Ban the Box law. They call it the Fair Chance Act, where the employer really needs to bring in their background screening vendor when doing the pre-adverse action and giving the applicant all the information they utilize, in making that employment decision. The consent form, again, must be on a separate document. It must be a standalone document, separate from any kind of internal forms, because it has information on there that is regards the background screening company and who's doing the background check, and it's extremely important. The applicants have certain rights once an employer decides to take adverse action. So, it's the applicant dispute process. This goes back to reporting and accuracy. I mean, if the crime that was, or the conviction that was reported by the background screening vendor, frankly, doesn't belong to the applicant has every right to contact the background screening company and say, hey, look, you reported information that doesn't belong to me, and this needs to be corrected. So how the process works is, and this is facilitated by us, is we give a pre-adverse action letter along with a copy of the background check and the notices again, so they get the notices again, and they have an opportunity to contact the background screening company within 5 business days, but Ban the Box now is kind of taking that in different directions. Some say 3, you have to keep the job open for 3 business days. They have 3 days to contact the background screening company and dispute the information. Some will take it 7 days, but kind of the FCRA states that it's 5 business days that you got to give the applicant an opportunity to contact the background screening company. They contact the background screening company. If the background screening company feels that a reinvestigation must be done, they have to notify in writing to the employer and the applicant that a reinvestigation must be done. They have 15 days to complete the reinvestigation. It could obviously be done much sooner than that. And the employer has to keep that job open when the reinvestigation is being done and when it essentially is completed. So again, when an employer is going to make an employment decision on background, they have to follow the pre-adverse and adverse action process. And we handle that and facilitate that, for our clients. Moving on, again, so with fingerprinting, the DOJ and FBI databases does have major limitations on accuracy and reliability. I'd probably say at least half of the information on the LifeScan or DOJ and FBI databases wouldn't be reportable on a standard background check. But if you are in those specific industries like financial, they can make an employment decision on an arrest record for any kind of fraud or theft because of the nature of the job. So you really need to identify what kind of industry you're in and if it's regulated by the state or federal government when doing these types of searches. We recommend, utilizing our services in doing a traditional background check to, again, make sure that what you're getting on the LifeScan is accurate and, reportable. Federal and state compliant background checks is as valuable as a LifeScan fingerprint report. I completely agree. We can do an even better job than an online database. We understand big data, we understand the Internet of Things, but still in our industry, it's important to still use manpower and individuals and vendors that are on the ground in those counties actually looking at the case file as opposed to using just a database, if you will. Kind of wanted to wrap this up with the most important part of the background screening process, and that's having a policy. I really like to have this in all of the presentations that I do because this is where it starts. With any kind of initiative or program or process that an employer is going to be doing, they really need to have a policy in place because the main thing is deters any kind of claims of discrimination by job candidates. Why, for example, why is my credit report being done and not an individual applying for a driving position? Well, you're applying for a financial position within our company, you're applying for an accounting position, and pursuant to our policy, a credit report must be ran. It specifically states why the company is doing background checks. Is it part of a contract? Is it part of, a mandate by law that the employer has to do it? Is it just that they do it across the board on every single new hire that they get? Who's subjected to the background check? Is it just employees? Is it going to be vendors? Is it going to be interns, contractors? Who is subjected to a background check with the employer? And again, to deter any kind of claims of discrimination, it should be done across the board. It certifies that the company will comply with federal and state law. Again, we do background checks as part of the hiring process, and we follow both federal and state law when reporting this type of information. And a sample policy matrix on the right there, it kind of gives you a red, green, yellow on different kinds of crimes that are reportable. If it's, let's say, a DUI outside of 5 years, that's something that we could work with the applicant, especially if they're not in a driving role. If it's credit reports, let's say any judgments or public records within the last 2 years, the employer just frankly can't hire the individual. It's just too risky. So the background screening policy is extremely important and vital to an employer's program before they start even doing background checks. And this can be, brought up in court, and you specifically say, I had a policy in place, and pursuant to my policy, this is why we decided to take adverse action based on the criminal or credit or driving information that we got on the background screening report. And we could help with developing your policy. Obviously, there are certain industries that would have more information in the policy, than others. Negligent hiring claims, I just wanted to throw this in here. So a cookie company in New York hired an employee without conducting a background check. The employee then physically assaulted a customer, resulting in a multi-million-dollar settlement. That's just reckless on the employer's part. That's kind of an open and closed case. With smaller businesses that don't have the wherewithal to absorb a negligent hiring claim, it could eventually put them out of business. So being proactive, investing in your employees up front can really drive your company and become more profitable and stay out of litigation. Correspondent for 60 Minutes died in a fatal car crash. This was a very, very tragic story. And the driver that was driving the correspondent had a suspended license over 9 times and only had 1 functioning arm. No background check was done on them, not even a driver's history. School teacher sexually abused student and is held liable for $3.5 million. So these are real cases. They are still happening. Employers sometimes, employers are still kind of reactive. They have to get their nose bloodied in a courtroom before they decide to be proactive and do background checks. But with some employers, they don't get that second chance. And it's something that is very, very simple in doing, but is extremely, valuable. So takeaways from today is confirm compliance with federal and state law and ban the box. We have a compliance guide, a nationwide compliance guide with regards to ban the box, and we'll be happy to share that with clients, non-clients. And again, if you're operating in multiple states and jurisdictions, it's really important to understand laws in those certain jurisdictions and make sure you're in compliance. Validate that your third-party screening vendor is procuring compliant reports. Maybe a good idea to make sure that they are a member of NAPBS. And NAPBS is the National Association of Professional Background Screeners, and it's the only trade association dedicated to the background screening industry. So it'd be really, really good to ensure that your background screening vendor is a member of NAPBS and is doing best practices, is educating their clients on certain laws that are coming out. Implementing a background screening policy, like we talked about, having that policy up front is a good tool to have for any kind of discrimination claims. It's just completely being transparent on why the company is doing background checks, and trust the applicants but verify them. Trust that they do have the experience, they do have the education, that they don't have anything in their criminal past, but of course you want to verify that information and just make sure that they are being honest. Integrity is the most important thing, and you don't want to start off the employee-employer relationship with any kind of questions about their integrity. That's kind of it. I have my information, contact information here. If you want to reach out to me, I'll be more than happy to get you in contact with Shannon as well. I'm sorry I didn't put her information on here, but please reach out to me and I will give you Shannon's information, or I could be proactive and just send you her information when we are off on the call. And this PowerPoint slide will be available on our website in our webinar section probably by the end of day today. If you want the PowerPoint presentation sooner, then go ahead and email me. I'll be more than happy to share it with you. Let's go ahead and take some questions here, Shannon. So the first one that we have is, so we make the offer, and on the offer letter it has a consent to do the background check. Once they sign and return their offer letter, we then send the separate background check link through employer's choice to the applicant. That is absolutely correct. So we have a system in place. It's a very, very technology sound system. It kind of takes the data entry portion away from the employer. So how the process works is like Kim said, you give a conditional job offer. You then let them know that, hey, we utilize a background screening vendor to do a background check. They'll be reaching out to you. And what we do is we send a link through our system to the applicant. They're able to access that link from any device. They simply click on the link. It opens up our gateway, and they input their information. They input all their Social Security number, date of birth, name, address. If we're doing employment education verifications, they'll provide all that historical information. It's completely secure. We firmly believe right now, especially in the day and age of hacking and cybersecurity, we have a very robust system that, yes, we leverage technology, but we also make sure the security is in place too. That link also provides them with any federal and state notices up front, so the employer doesn't have to give that as a separate item. And it essentially has the pre-adverse adverse action letters already uploaded, and it comes right back into our system, and it really streamlines and automates, the system. So it's a very kind of new feature that we have, and a lot of our clients are utilizing that. And we integrate with applicant tracking systems as well. So for those enterprise clients or even smaller clients that have a proprietary kind of onboarding system, we could integrate our background screening portal with that, and the exchange of the information is much more secure and doesn't have to be regurgitated by the employer logging back in, having to input the information from a paper disclosure form, that the applicant completed. So I could definitely talk offline more with anybody that is interested in that feature. So it is a good idea to leverage technology and putting the onus on the applicant. And you could tell the applicant, these links are good for 24 hours, 48 hours, and you have that time to complete it. If you don't, then it's pretty much a sign that you don't want to process with our company. So that's the only question I have. If anybody has any other questions, please put it in the chat feature. Again, this webinar will be uploaded to our website in the webinar section by the end of day today. If any questions come up later, by all means, please reach out to me. And if it's something that I can't answer, I will definitely bring Shannon on board, and she could work through it as well. So we have about 10 minutes left. I wanted to get everybody out of here on time. I think we did a good job of that. And again, wanted to thank you guys for taking the time out. I know you're extremely busy, but this is very valuable and important information that employers must know, because this industry is changing. It's very fluid, and with new laws coming out, employers really need to know what their rights are and what the applicant's rights are as well. So with that being said, I want to thank everybody. If you have any suggestions or anything that you want to hear more on, let us know. We want to tailor these webinars to our clients' needs, or anybody that just wants more information and education. So thank you again, and we look forward to having you back on our next webinar. Thank you.